Hi, this is Curt Verone.
And Brad Pinsky.
All right, and we are here for another edition of Fire Law Roundup for December 14th?
I think today's 12th.
December 12th of 2022. And let me just turn this off here, of course. That's the thing I try to avoid all the time. It just kind of comes in there and interrupts. But Brad, why don't you take us away?
That's what you get with a live show. You get all the drama and errors that happen. So we have some great cases today. I'm really excited to talk about them. Some are a little closer to me, some are not. But let's start in Sacramento. And before I get here and go through it, I just want to make a couple of comments so that nobody accuses Curt and I of in any way being racist or making racist statements. We are critically judging cases. And that's all I'm going to do is critically judge some comments in a way that can help others understand the issues. So I am not being critical of the allegations or insensitive. Anytime we talk about harassment or discrimination, we're always, people might say, oh, the way you said something, but I don't want anyone to take my comments any way other than as a matter of law. So, and you'll see what I mean when I get to them. But so we're in Sacramento. We have a firefighter who's alleging race discrimination. And what he's saying is that supervisors and colleagues discriminated against him because of his race, and he filed suit against the city and two of its captains. I haven't read the actual lawsuit, but I've gone through it, a lot of it in detail. I presume what he's effectively saying is that not only was he discriminated against, but that the city maintained a policy of discrimination or failed to enforce, which it did have a zero tolerance policy. In the law, we call those Monell claims, which is through its conduct or actions, it actually had a policy of, in this case, allowing race discrimination. I'm critical of the allegations here, and that's why you kind of had my disclaimer. And so I want to talk about it. So he to his credit, he says he's in the fire suppression division. He says it's predominantly white. In fact, there are 600 firefighters and approximately only 12 are African American. Right off the bat, that weighs in his favor. The rest I don't think is so much in his favor, frankly, but he said that the department has maintained a racist culture and that many supervisors and firefighters feel openly free to make racist comments or to exhibit some racism because they don't feel that their supervisors above them or the city will do anything about it. And he gives examples. Now, I want to go through these examples with you. But the problem is he says he heard a lot of things, and that strikes me. Okay, fine. He's using that to try to establish a culture, but what's really missing in this complaint is a lot of things that actually happened to him. There's some, but most of it is, I heard somebody said to another firefighter. And that may establish a culture, certainly, of racism or tolerance to racism, but it doesn't do a lot for discrimination. So again, this is why I'm critical. So what he alleges, I want to go through some of these. And look, if this is happening at your firehouse, stop it, right? I'm not justifying a thing. If these types of comments happen, when I was chief, everyone knew no way in hell is anyone going to tolerate this. We're not going to do this. We're not going to watch things. We're not going to make comments that, create intolerant or a tolerant atmosphere of any type of harassment or discrimination. But that said, let's go through it. So he says that supervising firefighters they either ignored racist comments or they tolerated race-based bullying tactics, which I don't think he makes out here, or they do little to discourage firefighters from engaging in racist behavior. And he said that violates the city's zero tolerance policy, right? So that would be hey, you got a policy, but you don't enforce it. And he says, as he gives a bunch of examples, but listen to the examples, right? And again, I'm not trying to be critical of him. I'm being critical of the facts or the allegations. So he says at one of the stations, he heard someone yell out, I just got to read it, right? I apologize if I offend anyone, but he says, fuck Black Lives Matter while they're watching a television show. Now, I have to tell you, I don't think that's a racist comment. I don't think personally that rises to the level of racism. And I'm not saying it's not insensitive or anything else, but that means you don't like the organization. And look, there is a lot to that organization. Here's where I'm going to get attacked, that people may not like. For example, the news that one of the heads of the organization bought a number of homes based on the fund, using the fundraised money. People may not like that. So there are things about the organization you may not like. That doesn't mean they don't like what it stands for. It means they don't like the organization. It'd be something else if they said Black lives don't effing matter. That would be a different comment, right? But saying I don't like the organization does not mean that you are racist. So that was one example, and it was a lead example. It wouldn't have been mine. He said another example, he said, I heard and saw a white firefighter walk around using a form of the N-word. Now, I don't know what that means, right? What a form of the word is. And look, any form of it is not acceptable. He said he heard about an incident with another Black firefighter who was asked by a white firefighter whether he saw himself more as a firefighter or a Black man. And I got to tell you, just as context, although it may strike you as, wow, that's a, insensitive comment, I could see a legitimate basis. I'm not saying there was one, but I could see a legitimate basis for the question. But more than that, and I'm not trying to justify it, right? I get why that would offend somebody. What do you mean? It's like saying, are you more an Italian or an American? Right? You're an Italian American. You're an African American. You're a Jewish American.
Yeah.
All right. But I get it. I get why, but I'm not so sure that indicates a whole, organizational tolerance. The white firefighter asks this question. Well, of course, I get that. So, there's that issue. Then he said he heard from a Black firefighter about an incident where a white firefighter referred to Black children as, I'm not going to repeat the word. I just not going to do it. I don't like the word. But in any event, yeah, that is definitely racist. And that may serve as, I would have led with that, but that, it's a firefighter, right? He heard from a firefighter. The question is, what he's leaving out is what happened. Did someone hear it? Did someone do anything about it? Did someone report it? He hasn't followed up with what happened. Just because people are making comments doesn't mean that firefighter wasn't then punished. So as a legal matter, I don't know that maybe he's established a prima facie case, but if this is the extent of his proof, I think he's got a very tough hill to climb.
Well, Brad, he's got some more detail in there, and just for purposes of making the post readable, I didn't include all of the details. Many of the details, like for example, and I'm not sure about all of those things, certainly not all of them, but there were certain allegations that he said that things happened in the firehouse, that an officer heard it and the officer didn't do anything. Now that, right, I think that is very, very relevant.
Yes.
But again, there's some reasons why as a person, you may have heard something happen. You may assume that an officer didn't do anything,
right? And
the officer, in fact, did do something. And that's another problem. And I know I kind of debate back and forth with some of our HR people about just how much information HR wants shared when an investigation is done. And this is a perfect example of where if HR doesn't allow us to let people know that we're doing an investigation and that people have been disciplined, people like this particular firefighter may assume that things are being said and nothing is happening, when in fact, things are in fact happening.
Right.
You just might not know about it because HR requires us, when we reprimand someone or discipline someone, we don't share that with anybody. So, but I will refer back to you now.
No, I think that's really the good point of this. That's the major learning lesson. At my HR conference I did 2 weeks ago, I said, listen, I don't care what the allegation is, whether it's sex-based, gender-based, race-based, you always do two things. You investigate and you train. And so I'm sure other attorneys may disagree, but my personal thing is, look, you drop a pin and that reverberates throughout the firehouse. There's no secrets in the firehouse, right? So the fact that anybody sued or said something or is being investigated, everyone knows. So I say, listen, investigate everything, period, and train regardless of the outcome. So for example, hey, we received a complaint. You're letting the entire department know we received this complaint and we are not tolerating it. Right? We're investigating it. We're not saying it happened, but everyone should be reminded that these aren't acceptable. And I think if you do those two things, you're going to defeat many claims like this, as long as you seriously do it, right? And you seriously announce it. Now, maybe after the 30th time in a week, you're announcing, we've heard this, we've investigated, don't do it. You've got a bigger problem.
Many HR people don't want you doing that. They don't want you to reprimand someone in public for saying something, and they absolutely will not allow the department to share the punishment of the person. So to everyone who witnessed it, it looks like the department tolerates that kind of behavior, when in reality, there were consequences. You may not know of them. I know, some fire departments have things like good conduct points and other things that can be taken away, vacations, other types of benefits, suspensions. People, somebody's out of the workplace, they might be on the roster as on, time off or whatever, but they're actually suspended. So, the point being, I think our HR folks, and I say this a lot, maybe too much, but what works in cubicle world is not going to work in the firehouse. And this is a perfect example of where these allegations are the department did nothing. Maybe the department did. And again, I'm not defending the department. Maybe his allegations are true and nothing was done. And then, the department needs to tighten things up a little. But on the other hand, it's possible that on these allegations, things could have been done and the department, for HR reasons, didn't make it known that there were consequences.
Right. And I just want to be clear. I'm definitely not saying announce any discipline, because I don't believe in that. But I am. Think,
so you and I disagree, and that's fine. And that's cool. That's
but
cool.
I do believe, even if there isn't discipline, even once you assume or once you receive a complaint, when you're done investigating or you're in the investigation, you remind everybody of the policy, right? It's not saying, and you can have a disclaimer, we're not saying anyone did anything right or wrong yet, but we are certainly saying don't do it, right? And I think that's really true. Look, we're about to investigate. We are investigating, but we just want to tell anyone, if this is happening, stop now. And I think that goes a long way to defeating a Monell claim, which is we tolerated, we have a policy, and that's why you and I are on one side of this and HR is on the other.
Right.
Okay, so I'll finish this up just to say there are specific examples against him of what he alleges are, race-based discrimination and harassment. I don't know that he doesn't say anything so severe. He's provided outdated materials, but maybe everyone else was provided outdated materials. From what I saw, he didn't say I'm the only one who was provided outdated materials and that it adversely affected me, which it would have. I mean, that would have been a big deal. He was set up to fail if that's true, but he doesn't say anything significant like we've seen in other cases where, severe and pervasive racism, but in any event. And then I want to talk about one last one. He says, I will quote this because I have to. He was called a fucking asshole. Sorry, anyone. And a firefighter told him you suck as a firefighter. That's not racist. As I always say, being an asshole is not a protected class. Maybe you are. As Chief Lasky says, I always like to quote him. Lasky always says, you should put down on the application a question. Are you an asshole? And later on, if you check no, but you found out he is, you can fire him for lying on the application. So anyway,
I'm not sure we could ever agree on the definition of asshole because,
firefighters have a whole new one.
Yeah, right. And I'm not sure that there's a fire chief out there that hasn't, someone at some point hasn't thought they're a fucking asshole. So daily. Yeah, or union president by the, let's be fair.
Right.
The two most hated people in a fire department are the fire chief and the union president. So.
Absolutely. So anyway, we don't need to beat that up anymore. We spent a good time on it. But I think the point is what you and I make to our line officers, supervisors, chiefs, and HR departments. I'm going to quote you, right? This is not the cubicle world. The fire station has its own dynamic, and you need to make clear through even if you're if you think, well, we have 25 stations and nobody knows what happens at station 1, station 2, you're wrong. Go spend a day and you will hear, hey, did you hear Lieutenant whatever on some shift I'm not part of did something? You've got to make clear that certain conduct is not allowed, whether it happened or not. Okay, let's quickly, let's go to Baltimore. This is horrible. I get it. Unfortunately, again, I'm going to raise some issues with it. This is not that I'm not on the side of the firefighters' families, but we don't take sides here. We just talk about the facts and legal allegations. But the families of Baltimore, of 3 Baltimore firefighters who died, and then there was another one who was critically injured. I don't know if they're part of the suit, but in January, they've sued the city, and they've sued because they did it. They got sent into a building. The building collapsed, and they said the building should have been torn down by the city, and it wasn't secured or demolished when the structure fire occurred. And had they secured and or demolished it, this wouldn't have happened. Factually, that may be true. Let's assume that would be true. Look, if there are no buildings, none of us would die in a structure fire. The problem with this is, and I don't know anything about Maryland's law in this regard, but, I raise a question. One, did they owe any duty to the firefighters? There's no direct duty owed to the firefighters. 2, was this a discretionary duty? Or was it just an accident? What happened, in fact, that it wasn't secured? Maybe it was secured, right? And maybe somebody broke in. Did it need to be demolished? I mean, demolishing a building is not inexpensive. It requires a lot of steps, environmental, in New York, at least. You have to go through a bunch of environmental factors and codes and permitting factors before you can just demolish a building. It's expensive. You got to do something with the waste. And, just saying you should have demolished it, I'm not sure they're going to meet any duty they owe to the firefighters. And then I don't know, maybe you do, Curt, is the firefighters rule in place that this was just a expected heightened danger of the job? Going into a building that could collapse, even a vacant one, is a normal thing we do in the fire service, searching for vagrants. It's not, so to say, well, you should knock down every building has a big X on it or has been condemned. That's would be a tough road to hoe, I think. And then there's no special duty, right? The city didn't owe a direct and special duty to the firefighters. So I'm going to be shocked if they win this, but I say that without, specifically knowing the law in this state, in this area. But that's a tough case. I don't know if you have a different opinion.
I couldn't find the complaint. I did check both the federal and state databases and wasn't able to find a copy of the complaint. The news was sort of mixed about whether or not it was actually a lawsuit filed or whether or not it was just a civil complaint. And the civil complaint being sort of a predicate to an eventual lawsuit where you have to go to usually the city clerk and file a claim. And the city has so many days or so many weeks to consider it. And then if they don't approve of the claim, then you can go to court. So I tend to think that that's the situation here.
Yeah, and you actually said it's a plan to file a suit. It's a notice of claim or notice of intent to sue, which, look, you have to do so quickly, right? You have to do it, which is a little late, strangely. If this happened in January, normally it's a 90 or 120 day time limit, but it's a procedural step you have to do. It doesn't necessarily mean that they're going to file suit, but if a client, so everyone knows, if a client comes to you and says, hey, lawyer, I want to sue, and you're like, oh, it's a municipality, I got to get something out quickly, you at least just send out the notice of intent to sue so that you don't get sued for malpractice.
Yeah, and you raise a couple of questions here, and one is that you have a city, and certainly as an employer within the fire department, you have a duty. There is a legal duty to your employees, but now you have a different city department that maybe owes a duty, but it's not the fire department, because the fire department isn't the one that's really responsible for knocking down buildings. So if it was the fire department, then you've got maybe a different issue.
Yeah, maybe they have the code enforcement division in their department.
Yeah, right. So usually, I mean, I know from my experience, it's usually the building department that handles demolition permits and goes through that whole process. So, you know, it's certainly in conjunction with the fire department, but it's really it's a building inspector's obligation here. So does the building inspector, because their employees now have some sort of a duty? Again, these are some of the issues they're going to have to wrestle with. I agree with you. I'm struggling to find you know, that legal duty, but on the other hand, they are employees, so you've got that. I know in the past there's been some use of our it seems like we are always talking about a Monell argument to try to federalize this, try to make it a federal issue, try to make it a constitutional issue, and denial of due process. So I don't know if they're going to take maybe to just kind of give themselves a little more leverage and go into federal court. Very often the reason I say that, we had a Baltimore case, we had a firefighter in Baltimore killed probably 10 years ago, a gal that was in training. She was killed in a training fire, and her family filed a a Monell based suit alleging a violation of due process. So it wasn't successful. But again, you may see them kind of go in that direction. So, you know, tough facts, and, you know, you hate to be like that Scrooge type person for the city saying, you know, we're not going to pay, when you really genuinely feel bad that we've lost, you know, 3 to and seriously injured a 4th firefighter. But
look, the code enforcement officer may be saying, I would have loved to make this happen, but there's regulations and permits and time and money, and we don't have it.
Well, and you know, I've got lawsuits. I've got suits against cities in my database that they also name the fire department. That's why I'll include them in there, for knocking down buildings. Basically knocking down buildings, particularly after fires, but other reasons why the fire department gets dragged into the lawsuit. But the bottom line is the fire department was instrumental in contributing to a building being knocked down before the building owners were notified, or the building owners had an opportunity to get their belongings out of it. This, again, several, not just one case, several cases. I'm guessing probably 6 to 12 cases. Wow. That are in my database that name fire departments. There's a whole bunch of them that don't name fire departments. Those are the ones that actually name the fire department as a defendant. So, you know,
I think facts that would make a difference, just because I have seen successful cases, but where the fire department pre-plans warns this goes a little bit different way, but warns the city, listen, you've got, or the town or the village, that you've got a very dangerous building. It's going to collapse. We saw New York City, FDNY had this, where they warned a building's going to collapse, and in fact, it collapsed the next day. And they were warning how dangerous it was. You got to get people out. It's one thing if somebody's ignoring warnings and non-firefighters get hurt, unfortunately. And the fire department's like, you got to do something. But I think it's a very tough case. I think it's unfortunate. I don't like the firefighters rule generally. I don't like that, that firefighters have a hard time suing because this is the expected injuries. But, even with the firefighters rule, if the landowner created the danger, right, or allowed a known danger to persist, then maybe it wasn't an expected danger. But anyway, we don't.
Well, that would be, and again, I think the firefighter rule is going to go more toward the building owner. Right. But on the other hand, very often when you're dealing in a scenario like this, where the building is in disrepair, the owner is being not responsive, the city can come in, whether for back taxes or other things, and take possession of it. And there's actually been some litigation over going after a bank, because the bank has basically, a bank. Sorry.
Pager going off?
Yeah. A bank has sort of repossessed the property, and they're still trying to figure out, what do we do? What do we do? Do we want to? Do we not want to? And then there's a fire, and firefighter gets killed. And so now the bank is one of the people that's, in the gun sights of the plaintiff's attorney.
Right. And now, look, we also don't know the cause of the fire, right? If it was arson, you might say, how are we supposed to stop an intentional act?
Yeah.
But anyway, okay.
I got to assume it was arson. I'm sorry. Vacant building, mice playing with matches.
Yeah, exactly. Exactly. No electricity, but somehow an electrical fire started in 5 different places in the building. Okay. Let's go to Boston. You really make some interesting points about this. In Boston, we have a firefighter seeking, I don't mean to laugh, I apologize, but $8.3 million, actually $8,342,068. Very
pretty
specific.
Precise. Yeah, very precise.
Some paralegals spent a lot of time doing some work on this. In any event, and this is over a COVID vaccine suspension. Now, before we just kind of crap all over the claim for a second, remember, we've just had now a court saying, look, your policy of not allowing someone to not accept the vaccine wasn't reasonable now, even when looked back years later or before, because we know the vaccine isn't necessarily effective at preventing variants, et cetera. But so with that one case in our background, I'm not so willing to just, crap all over a claim, but he's saying that he was, and it's just a file, he's filing a lawsuit. He's saying that he refused to get the COVID vaccine due to his Muslim faith and his I think because he's African-American. And then you point out that the complaint doesn't really say anything about it. There's no causes of action about that. So
it's really kind of a strange, I hate to say this, I want to insult brother and sister attorneys, but it almost looks like a class project in a law school where maybe it's a torts class or breach of contracts class, and you're given a fact pattern, you're told, all right, draft a complaint, but you can't make a discrimination. Here's the facts, but for whatever reason, you've blown your statute of limitations, or you can't allege race discrimination. So figure out a creative way to sue based on tort and breach of contract.
Right.
And so, and what you see is I'm reading the factual allegations in the complaint.
Waiting.
I'm waiting. And I'm like, where are they?
Right. Well, what can I tell you? If you're somebody who's thinking about filing a suit over COVID and mandatory vaccines, and don't. You got one case in your back pocket, but you've got some very, very high level federal and very high level state courts saying, don't waste your time.
The assault allegation, I can't wait to see.
I don't understand it.
You threaten to stick a needle in me. Is that the assault?
Well, it is technically an assault, except I didn't show up. So I don't know. I don't know. Okay. So I don't want to that's I got nothing to say about that. Let's go to Washington, our good friend, John Murphy. We're going to go to his area, Snohomish. Here we have and look, this is a topic. Before I get there, we've seen claims and verdicts for tens of millions of dollars. I don't think this is going to be one of them, but we've seen harassment cases of trainees result in significant verdicts of harassment. I just don't think this will be one. So here we have a Washington State firefighter who claims he was sexually harassed during his fire academy training by an instructor. Now, look, on the basis, of course, that's serious. He named, the county, the fire protection agency, the fire and rescue department. He names a lot, but he's a firefighter. He said that an individual, let's call him trainer, that had harassed him and other recruits while they were in training at the fire academy in 2019. And he said that the trainer, who has since resigned, had been a firefighter with the city since 18. So maybe he's saying he had a history of it.
Yeah, you hadn't been a firefighter for very long. That's why I don't understand how somebody who's hired in 2018 is now working at a regional fire academy in 2019. You should still be on probation. What are you doing being an instructor?
Right. What do you have to teach? In any event, that's not the issue, but it's very strange. But anyway, he's apparently serving as the instructor, right? Based on 1 year in the job. In any event, you couldn't find the complaint, but there was a report that was found by, I think, the TV agency that said, look, the city already determined that his conduct was inappropriate. So there's, in many states, if a supervisor, and I don't know that he was a supervisor, if a supervisor harasses someone, you lose because the supervisor's conduct is attributed to the city itself. Whereas a firefighter's conduct, like we saw in the race allegation, right? A firefighter's conduct is not enough unless a supervisor knows about it and fails to do anything. Here, the claim is that this trainer engaged in unethical and unprofessional behavior towards the probationary employee, and he would act one way in front of the probationary employees and another way in front of supervisors and other company officers. That's the problem he's going to have. But what's missing is the statement that I told somebody about it. I question, it seems like he's more saying he was harassed, not sexually harassed. I don't see specific allegations. Again, we don't have the complaint, so we don't have the specific allegations.
Yeah.
So there's not much more to know about. I don't want to waste too much time on that. We have more interesting ones to end up with.
Yes, we do. Yes, we do.
So let's go to New York. I'm in New York. So let's go to New York. We have a very interesting, the facts are fairly simple. I did some legal research on this. I do not represent this company. This is a for-profit agency, and most people know I represent probably about 70 or 60 ambulance companies in New York, but mostly they are the not-for-profits. Doesn't matter, but I'm just announcing this is not one of my clients. This is a downstate entity, but they are facing a class action lawsuit, right? That's serious. A class action lawsuit, let me explain why it's serious, is because these are expensive. They're complicated, they're expensive. They're tough to prosecute generally because you got to get everyone, there's a lot of steps to go through to get a class certified. In any event, they sue an ambulance company, Empress Ambulance, as many know, for mishandling protected health information and failing to disclose a data breach timely. I'm adding that one, and timely as required by HIPAA. Now, they filed suit. Basically, what happened is there was a breach by a hacking, kind of entity.
Russians.
Yeah,
Russian
I think,
hackers.
right? Wasn't it?
Yeah.
And
I think it was, yeah.
They disseminated disseminated a lot of information. They took credit for it. The timing, I'm not 100% positive on, but they allegedly took over 300,000 names of individuals' information, and it was protected health information. The allegation primarily is, and I'm going to read another case to tell you my 2 cents on this. The allegation is that they had a duty to implement reasonable, adequate industry standard data security policies to protect the public health information. Now, they're sort of relying on HIPAA. They don't name HIPAA, as you point out, and I can say it's because I have the case. That was my case in New York State that makes clear 2 things. 1, there's no private right of action under HIPAA, and 2, HIPAA only applies if you electronically bill. Now, here, they do electronically bill, right? But to the first part, HIPAA doesn't have a private right of action. You can have a civil claim where the government can impose some very serious money. Usually it's $50 for one unintended breach. It can go in the tens of thousands for repeated allegations. But again, the primary allegation here is that Empress had a duty to protect the information, but they failed to do that. And that's part A. Part B, that once they learned of the breach, they failed to let everybody know about it in a timely manner for about 2 months. Now, that's going to be hard to prove that resulted in actual harm, but I went a different way. I started doing a little research because I was interested. They named the general business law, and they talk about the general business law saying you harmed the consumers have a right to be protected. And so I found there's only one case in New York that actually cites that section. And while the judge says, yeah, under that section, there could be a private right of action, they threw out the case, that, or at least that cause of action, saying that there's a very high standard, and you can't really award actions for this or damages for this type of injury. I won't get into the comparisons, but they threw out that cause of action. So in the same case, same type of circumstances, another plaintiff lost. They said, let's see, this is a 399, right? There's a whole bunch of them. So
349?
Is it 349? Hold on. So I've got a whole list of the general business laws. Let me find them. So here it is. It says, let me read this long paragraph. General Business Law 349 provides that deceptive acts or practices in the conduct of any business, trade, or commerce, or in the furnishing of any service in this state is hereby declared unlawful. Okay, there's the rule. A private right of action, says the court, to recover damages for violations of the GBL has been provided to any person who has been injured by reason of any violation. So you can sue under it. However, they say under GBL 349, a prima facie case requires a showing that the defendant engaged in a consumer-oriented act or practice that was deceptive or misleading in a material way and that the plaintiff has been injured. The court goes citing a long list of much higher cases. This is a lower court case, but they cite higher case. Here's what they say. This is very interesting, where I think they may be doomed. Here, despite the broad language contained in the complaint, the statements allegedly made by defendants in the privacy policy and online notices do not constitute an unlimited guarantee that patient information could not be stolen or that computerized data could not be hacked. Defendants allege failure to safeguard plaintiffs' protected health information and identifying information from theft did not mislead the plaintiffs in any material way and did not constitute a deceptive practice within the meaning of the statute. So that part got thrown out. That's going to be a very tough road to hoe, and they're citing some very high courts, the appellate divisions in New York State. This is a lower court case, Abdel versus North Shore Long Island Jewish Health System, but they cite some significant cases.
Well, Brad, I want to kind of take it back, and just because not everyone, I know exactly where you're going. I'm not sure everyone kind of is following all of the, the connection between the disconnect or the connection between HIPAA. Bottom line is, you have an ambulance company. They've got to comply with HIPAA. HIPAA says, number one, you've got to safeguard protected health information, and you've got to do that in a way that you have encrypted the data, that you secure the data. You've got to have a system. You've got to have a plan. You've got to have training, all that stuff. So any of those constitutes a HIPAA violation of any of those, okay? And in addition, a great deal of what really HIPAA is focused on is, what do you do when there is a breach? When you become aware of a breach, you've got to do certain things, okay? So this ambulance company, whether intentionally or not, didn't comply. And so now we've got a class action against them, but it's not, they're not suing under the class action based on HIPAA. So kind of wink, wink here, right? It's not based on a HIPAA violation. It's based on, as you're going through this now, violating the
General Business Law.
General Business Law 349 on deceptive acts, which sort of as a predicate assumes that there's this violation of HIPAA, and that basically this ambulance company is saying, we comply with HIPAA, and they don't. And that there's some sort of a deception in there, okay? So that's how we're going from HIPAA to this law, because HIPAA...
it's like NFPA, it's a standard.
Right, that's another way to look at it, but the federal government can come in and enforce HIPAA and go after this particular ambulance company and sue them, fine them, and require them to comply better and all that. That's what HIPAA allows. HIPAA doesn't allow someone whose information was stolen to then go after the ambulance company. So now this particular gentleman, and I'm not sure what his relation, some people have a profession of being plaintiffs in class action cases. And I'm not sure if this gentleman is, or whether he is legitimately someone who was injured and, is highly motivated. But, Robert D'Agostini is the plaintiff in this case. But he's the one who filed. But again, he's not alleging a violation of HIPAA as his cause of action. He's alleging a bunch of things. And I'm trying to get to a point where I've got a question for you, because you have had a similar case. You represented the defendants in the case, okay, and you won, okay? And here's my question. One of the allegations in the complaint is negligence. And we're saying that HIPAA does not create a cause of action. Can HIPAA create a legal duty, the breach of which would be negligence?
I think if you had which they have tried, a separate standalone statute, that's why I'm like, hey, it's like NFPA, right? You can't sue under the NFPA, but it's a standard. Right. The problem is, so I think the answer is yes, right? HIPAA can serve as the standard by which you're obligated to do or to adhere to, but they have two problems. One is, just because someone hacked you, right, doesn't mean you've violated the standard. What they did probably violate, maybe, is they didn't notify people timely. Now, they rely on general business law, right? So there, I think they lose, because what the court's saying is, look, there's no contract, right? Just because we told you we're going to protect it, protect your data, and we're going to do what we can, it's not an absolute guarantor that nothing's going to happen. And in these days, you can't, right? But part of this is you didn't tell us quickly enough. And I understand that. And there certainly can be damages for, had I known 2 months earlier, I would have changed passwords. I would have done something. Now here, what are you going to change, right? What are you going to change with the fact that your health information is out there? It's not necessarily financial unless your credit card information is there. So there may be that duty which they violated, but proving damages, I think, is going to be tough. But the other question I had, and I think I know the answer, there is the Electronic Communications Privacy Act. There's other things that they could have sued under, but I'm wondering, A, do they provide a private right of action? Or B, they just didn't want to be in a certain court by alleging those statutes. I don't know the answer to that. Somebody either made a well-reasoned or a poorly reasoned decision to rely on this, but this took me all of about 5 minutes to run down the statute. There were only 3 cases under GBL 349 that dealt with something like this, and only one of the 3, the one I just read, really dealt with breaches of electronic health information and private information, and the court throws it out. So that's why I started with class actions are expensive. So maybe they said, look, everyone's got $20 of injury, but we got 349,000 of them. Multiply that by 10. We've got $3 million. Divide that by 3. We've got, the attorney's fees of $1 million, unless this statute provides attorney's fees. But still, it's like, it's the class action that, hey, the credit card overcharged 1 million people a penny, right? So they've got the numbers, which is why the class is going to be, they got to certify the class and notify everybody, and they only need to win $10 per person, and this law firm makes $1 million, right? So I think that's the reason this is really happening. But if I am the defendant, tomorrow, I am filing a motion to dismiss before they even get to certify the class, to say they can't, even if the allegations are true, they lose. I think it's a tough road to hoe, but I understand why they're doing it. And the reason they're doing it is 300,000 people. And
what was the name of the case that you won on very similar issues?
Oh, Szymanski versus Bellevue Fire District.
Okay.
And there the court held, one, HIPAA doesn't apply to fire departments who don't bill, and at the time they couldn't. And more than that, there's no private right of action under HIPAA. And I got to tell you, I doubt the plaintiff's attorney who sued it is watching, but he stood up in court and said, I apologize for filing this had I known. He was a stand-up guy. We were applauding him for saying, you know what, I should have done my research. So we applauded him. I complimented him to the judge, and, that's how attorneys should act. But nonetheless, the court still held no private right of action. And I was able to cite a lot of
no sanctions. Were there sanctions or anything? Or
No. We didn't ask him. He was so nice, and, we got rid of it on a motion, but you can't
nice when you deal with nice attorneys,
Exactly.
It's a pleasure. It is a pleasure, So.
It is. So I think, the question you raise is a better one. Is HIPAA a standard? But most of their case really, I think, is not going to be you didn't protect it properly, though maybe they didn't. But I got to tell you, they use an electronic PCR program, I guarantee, and all the major electronic PCR programs, as you know, are, certified, NEMSIS, Gold, HIPAA compliant. And I just have a hard time believing that, the way things were stored weren't properly protected. But I don't know. We don't know. I don't know what Empress did. But it's a tough road to hoe. If it wasn't protected, that may be an easier case, right? If they didn't comply with the standard, that may be easier, because then they said, hey, it's protected, but it wasn't. But so let's go to your point. We'll kind of end with this. If I had to do A, B, and C to protect anything, the information, and I told you, hey, your HIPAA information is protected in accordance with A, B, C, but I've only done A and not B and C, maybe that is fraudulent. But according to this case, it's still not a contract. Right. The GBL does not provide a contract. HIPAA probably doesn't provide a contract on, that to give you a private right of action.
May create a legal duty, but it may not. Besides creating a standard, the question is, does it create that legal duty that's going to be necessary to prevail on a negligence claim? Right. So,
So tough case. But again, you only got to win $10 a person with 300,000 of them to make this worth somebody's time. So that's it for today. Those are great cases, and we look forward to next week.
Yeah, absolutely. Brad. All right. Well, thank you very much. And everyone, will see you next week.